If you've ever seen the little TM symbol after a name or an icon or a logo, then you may have wondered what it is. Or you may have asked your attorney, what is a trademark and why do I need one? I'm Erin Jackson with Jackson LLP Healthcare Lawyers. A trademark, very simply, is a way of protecting your brand. Whether you protect your name, your logo, or your tagline, it's a way of telling others and warning off copycats that this is yours. So there's 3 basic ways to get a trademark. They're not mutually exclusive, so you can pursue multiple ones. The first is through use. Now, this is called a common law trademark. It basically means you were the first one to start using this name, and you've continued to use it. You've operated your business under it, and it's become your trade name or your brand name. Even if you don't file anything with the federal or state trademark authorities, you still have a trademark. This is called a common law trademark. The second way to get a trademark is through filing a federal trademark application with the USPTO. That's the U.S. Patent and Trademark Office. This is sort of a complicated process, which involves having an attorney perform searches for similar business names, similar logos and uses. There's all sorts of categories, and it's sort of a critical analysis that we conduct to advise a client as to whether it's a good idea to file for trademark protection or whether filing for trademark protection might actually give somebody whose name is sort of similar to yours a heads up that you're operating under a similar name and could actually potentially subject you to more liability by letting the public know that that's the name you're using too. So we do always want to do a critical analysis before filing with the USPTO. The third way of getting a trademark is a state trademark registration. So each state maintains their own trademark registry, and this is usually far more cost-effective than the federal option, but you do want to do sort of a mini version of the analysis that we do at the federal level. Now, some people use a trademark in common parlance, so they have a common law trademark, then we file it with the USPTO, and then we file it with the state trademark authorities, and they have all sorts of trademark protections. Now, the benefit of having the filed or registered trademark is that if someone infringes on your trademark, that is, you go out tomorrow and you see somebody operating a very similar business to yours with a very similar logo or very similar name, you could say, hey, I have registered that trademark. And so that's really clear evidence that this is yours and you already sort of called dibs on it. So it makes policing your trademark and making sure people don't infringe on it a little easier. That said, it's not required, and we can absolutely help with policing trademarks that are not registered. If you have questions about any of this or whether your material is appropriate for trademark registration, feel free to reach out to us. For more tips on staying compliant, subscribe to our YouTube channel.